Hello, everyone, and welcome back to the University. Today we have the February 2020 hearings in the Raymond Tyrone Davis trial. The first occurs on February 3rd, and it's a notice of witness and a motion to dismiss the case. Then we have February 5th, which are arguments on the motion to dismiss, and this was really interesting. We have a very brief, less than 1 minute hearing on February 19th because neither of the attorneys, the prosecutor or the defense attorney, were available. And then on February 24th, we have another motion to dismiss counsel. It's unreal. Absolutely unreal. Let me know what you think in the comments. I hope you enjoy.
C342946-1, State of Nevada versus Raymond Tyrone Davis. Mr. Davis is present in custody. Ms. Mueller on his behalf. Ms. Collins on behalf of the state.
Good morning. I'm Craig back, Mr. Davis.
Good morning. All right. So before we get started, Mr. Mueller, I believe that there was another motion to dismiss counsel filed. Is that correct, Mr. Davis?
Why not?
Do we still need to discuss any motions to dismiss counsel, or have those already been?
Already failed to the Supreme Court.
Okay. And you haven't filed any new ones?
Not received.
Okay. Sorry about that, Mr. Mueller.
Thank you, Your Honor. I'm ready to proceed with the motion to dismiss.
Okay. So that wasn't on my calendar today. I am prepared. I did review. Ms. Collins, what did you want to do?
You know, I reviewed it. If the court needs something in writing, I'd be happy to provide you that by Wednesday. I wasn't able to accomplish it.
Right, so it wasn't, when did you file it? Because it didn't show up.
It's like 5 o'clock on Friday. Both his notice of witness and this motion was filed. They called me about 3:30. And himself and Mr. Polaris called me about 3:30 and asked me if I had it, and I said no.
Okay.
And then it went through e-filing and filing.
Okay, so we can do a couple of things. We can, if you would like to address it orally, I'm happy to do that. If you would want to do something in writing, we can pass it till Wednesday. I'm happy to do that.
Well, so procedurally, because we've already had a hearing, and I don't know if the court drafted an order for the last hearing,
So what I did was, I did draft an order, but I waited for Nzunza to come out, because if you remember at the end of the hearing, I said, I'm happy to readdress this once we get clarification from the Supreme Court in Nzunza. And so I wrote my order, and then Nzunza came out at the end of December. And so I knew we were going to be in this position, and so I
hold off.
well, yeah, I'm just waiting to hear your guys' arguments on Nzunza.
So I guess my position is this, you know, without having the guidance of Nzunza, I don't know that I put forth everything I should have in terms of rebutting any prejudice to Mr. Davis at that hearing, because I didn't know that that was what was required before the guidance of Nzunza. So I would like a chance to review that and see what I have in the record and give the court something in writing if I could.
Yeah, that's fine.
I can argue whatever orally you want me to today, but I don't want to cite to a record not having the transcript.
So when I looked through everything, in regards to the, hold on, let me go down my memory, just 1 second. I'm trying to remember exactly what. Oh, in regards to the rebuttal that I went back and read through everything, the rebuttal and you guys can both tell me if you disagree, but the rebuttal that I had read was that there were 2 witnesses that Mr. Davis had pointed out that he would wish to use, and he pointed out that one had passed away before the actual case was filed, or excuse me, while the investigation was still ongoing, and then the other one was alive, and he had passed away the January before the hearing. So you had discussed that he was alive during that, and then something about the Fatburger videos, you had the detective testify that those get reburned every 30 to 90 days. So you had presented that, but if you wish to go back and read more, I'm happy to.
Well, look, I do. I just
yeah,
want to be
that's fine.
cautious.
So I think what we need to do though is, I don't think this affects calendar call, and let me tell you why. If it gets dismissed on Wednesday, then there is no trial, and if it doesn't get dismissed, we're going to trial. So that's kind of where we stand with trial. So I'd like to figure out where we are in regards to that first. So, Mr. Mueller, in regards to trial.
Your Honor, we can be trial next week if the court, for whatever reason, doesn't agree to grant Mr. Davis relief.
Got it? Ms. Collins?
State will be ready to go to trial next week. Mr. Mueller filed a witness notice on Friday at 5 p.m. with over 20 people on it.
Okay.
There are no phone numbers included with that. I would just ask that he provide phone contact information. My investigator, there's no way she's going to be able to physically track down over 20 people on this week.
Okay. Mr. Mueller, do you have contact information for those 20 individuals?
I'll give the state everything about that.
Sounds good. All right, so we will start Monday at 1 o'clock unless the case gets dismissed on Wednesday.
I think going forward, I'm going to say, Judge, my memory is not quite what it could be anymore. Too many cases rattling around in there.
Yeah.
If memory serves, we took a full evidentiary hearing, called several witnesses. I have not been able to locate a transcript that was prepared from that trial. Can we get the court order the clerk to get the jabs, so I can at least refresh the jabs for argument on Wednesday?
I'm sorry, you're talking about, the docket hearing?
Yes, we did a full-on hearing, I remember
Yeah.
calling the detective.
The transcript's in Odyssey.
Yeah.
That's where I
Oh,
read.
there's
There's a full transcript.
prepared?
That's where I got when I reread I read the whole transcript, yeah.
Right, so the transcript has been prepared. Okay, we
Yes.
didn't pay for it, that's why I was asking.
No worries.
Let's defend this motion to dismiss counsel February 5th, 9:30.
Okay.
And Your Honor, I think before the state told you it'd probably be 6 days of trial. I don't know what his witness list adds to that.
Okay, all right. Sounds good, so we'll see you guys on Wednesday at 9:30 for argument.
Thank you.
Yeah,
Thank you.
sounds good. One, State of Nevada versus Raymond Tyrone Davis, page 33. He's present in custody. Mr. Mueller on his behalf, Ms. Collins on behalf of the state. This is the time and date set for defendant's motion to dismiss pursuant to docket. I did receive the state's opposition as well as Mr. Mueller's supplement and addendum.
All right, thank you, Judge.
So I've had the opportunity to read everything. Mr. Mueller, this is your motion. Go ahead.
Thank you, Your Honor. There's a presumption in Inzua, I guess the case is pronounced, the Nevada Supreme Court found a gross negligence and dismissed a 26-month delay in serving a warrant where they knew where the man was in custody on the other side of the country and had to be extradited back. Here, every factor that favored or mitigated towards a dismissal of the indictment is actually significantly worse. Here we have a 31-month delay. Specifically, the detective who actually worked the case out had been in Mr. Davis's apartment, knew exactly where he lived. 31 months later, they issue a warrant, and no one goes over and knocks on the door. They don't leave a red card at the door. They don't make any meaningful effort to serve the warrant. In the intervening 31 months, Mr. Davis is a well-known poker player. He actually has a very high profile. He actually works and runs a local business that advertises. All one would literally have had to have done is type in Ray Davis, Las Vegas, Nevada. You'd have seen his picture, his business location, and his business. The state made exactly zero effort to serve this warrant. In the intervening time, we don't have to discuss hypothetical prejudice. We had 2 witnesses pass away. Mr. Davis has been a successful poker player. Poker, as I'm sure you probably know by now, is a social activity. Poker players tend to flock with each other. They run in groups. He had poker players who would routinely come up and stay at his apartment, and he'd go down to California and play poker with them as well. 2 of the poker players who could have said that this woman was never in the apartment, or at the time he was at our apartment, that would have been available in defense. Now, that's not a theoretical construct. That's actual prejudice. Now, what did you do last week, Judge? Well, I bet I know you were for the Super Bowl game. You probably remember that. How about the Super Bowl game 4 years ago? Where were you? Who played? Who was with you? How much did you have to drink? Those things pass with the passage of time. And this is a sex case. Because everyone's memory, sex is a semi-routine thing after a while. And remember, you did an analysis here when you found negligence initially. Well, we did a kind of incomplete analysis because we talked about delayed disclosure. This isn't a delayed disclosure case. Children occasionally come forward years after the fact, as you correctly pointed out. That's not this case. This is a delayed prosecution case.
Wait, hold on. I thought that there was a delayed disclosure of like a year to a year and a half or something.
It wasn't that, though.
Yeah.
That is correct, Your Honor, because the charging years are 2014, 15, and the disclosure is in 16.
Okay, a year, but
Okay.
the prejudice that has transpired is negligence, not through disclosure.
No, I just wanna make sure I had the right facts.
Okay, yeah, no, okay, I'm sorry, I don't think of it in that terms, the one focusing it is on the disclosure from the date to this prosecution date, that's the problem here. Information is effervescent, it has lapsed. Many of the details that she asserts could have been either verified or refuted had we had the case in any meaningful, reasonable amount of time. Now, this is a straight through speedy trial. It was denied Mr. Davis. It was denied him effective assistance of counsel because of the passage of time. Delay was through no cause of Mr. Davis. In fact, he invoked his speedy trial right. In fact, we was in here arguing very vigorously just last week about his speedy trial rights. He's invoked all the time his speedy trial rights. So the delay was in no way, shape, or form caused by Mr. Davis, and I was unaware of the case. So respectfully, I don't believe that there's any meaningful rejoinder that could be had. The analysis on the Insua case is completely cogent and on point here. Every factor that they found, we can add to. You okay, sir? I'm sorry, don't mean to interrupt. It was okay. So respectfully, Judge, with the outlines for the reasons, I went ahead and reread the transcript, and we put appointment and authority. We've got the initial motion. I believe the court really has been given no choice but by the state's inactions on this case, but to dismiss the case for lack of speed trial.
First of all, Your Honor, I do want to supplement what was brought forth at the evidentiary hearing, because I think what happens in this case factually is different than in Zunza. Upon research looking for case notes from the detective that was assigned the warrant when it came out, we came across an entry in NCIC that was actually made in 2017 by Metro, which entered all of defendants' AKAs and all of the dates of birth that he was using and his social security numbers. So in 2017, we know somebody was still looking for him.
Can I see that, please?
Yes. May I approach her?
I'm gonna, I find that, I'll wait to rebuttal, Judge.
Okay.
Oh, so the point being that the warrant just didn't come out and nothing else transpired after the warrant came out. It's just one more fact. So we were here last time, the court agreed that the time that passed, triggered the analysis.
Correct.
So now we have to, discern what is the reason for the delay. Well, the reason for delay is the way that Metro handles their warrants. They come in, they're assigned to a CAT team, and that's what they count on to pick them up. That's how they count on these defendants getting arrested. This is different than in Zunza though, because in Zunza, Detective Hoyt, sorry to call him out by name, I shouldn't say that, just sent the case off and never followed up. And then he was approached with very specific information on multiple occasions about where Nzunza was, with Facebook, with a photograph of him with his, the establishment where he worked and his work truck. So Detective Hoyt was given a couple opportunities with specific information. Metro never had that with Ray Davis. I mean, nobody came to them and said, here he is, he's right here, go get him, and they did nothing. I mean, obviously, by modifying the warrant entry, they're still looking for him. He has, I believe in there's 10 AKs, several birth dates, several social security numbers. So they were still making an effort. Would it have been nice if someone went to his apartment again? Certainly. We can't prove or disprove that. The case notes For that detective that is retired, those don't exist. We reached out to him, he doesn't remember Mr. Davis's case, he was retired, I think his name is Detective Giovanni. So that's where the gap is, and I understand that, but there isn't the level of inaction, I think, here that rises to the gross negligence that they found in Nzinza. I would agree with you that it's negligent, but I don't think it's gross negligence. Given the information that the detective knew of in Nzinza, and that was like, absolutely, this is where he is. Mr. Davis has California driver's license. When he was arrested in this case, he said he lived in both California and Nevada. By his own testimony, he was back and forth, California to Vegas for 3 months at a time, 2 weeks at a time, a week at a time. It would be concrete if we had someone that went over there and knocked on the door, but we don't. But I don't think what happened with Metro in this case rises to gross negligence. So then when we get to the prejudice prong, the witnesses he complains of, one of those witnesses passed away in February of 15 before this case even came out. So that should be deemed rebutted. There wouldn't have been, by the time this kid disclosed, there would have not been any forensic evidence that we would have been able to acquire. We wouldn't have been able to go in on a search warrant. As to the victim remembering specific dates of offenses, there's a jury instruction. We don't require sexual assault victims to recall specific dates and times. We just require them to give a time frame. Additionally, they filed a witness notice that has 20-some people on it. I mean, obviously, he has not been deprived of a defense. I mean, they filed an alibi, they withdrew it. They have their new witnesses that they've proffered. I mean, obviously, they have a defense to their case. So I think this is distinguishable from Nzinza, in that regard. Do you have any questions for me or anything I can clarify?
I'm just thinking about the ruling in Nzinza. I've read it so many times, and I'm just trying to think if I need clarification. I don't think so. Mr. Mueller?
Your Honor, the state has to produce evidence, not suspicions or suppositions. They have to show some immediate buffer to locate. These facts are significantly more egregious, not less. The detective was in his house. The detective knew where he lived. He knew his name and knew his phone number. He's a local businessman. All you literally type in Google right now, Ray Davis, and you'll see his business comes up, Real Grinders. It literally would have taken a soul who cared about 20 seconds to get a good lead on Mr. Davis's whereabouts at any given time.
Oh, I know what the question was. I wanted for both of you. Sorry.
Okay.
It was the CAT team, what it was testified to is one thing that the CAT team does when they're assigned the warrants is they do the search in like either NCIC or driver's license and see that so they basically work on is the individual in state or out of state. And here the information would have shown that the defendant lived out of state, which affects what they do in state. So I'd like you both to, do you guys remember that testimony?
I do, because he had the California driver's license.
Right, and so I just wanted each to address that.
Your Honor, a couple of very key points. And the key analysis here is that the right to a speedy trial attaches to all of us as a constitutional right. The fact that the police department is organized so Mr. Left Hand doesn't talk to Mr. Right Hand, literally all that detective would have had to have done is picked up the phone and said, hey, he says he's got a California driver's license. Oh no, he's got an apartment, I was in it. Those are the photos of his apartment. Literally, could have called the apartment complex, hey, has Ray Davis still got an apartment there? Yes. I mean, we are talking such a minuscule amount of effort to locate him. He's a man who's made it a point to have a high profile. If you look me up, 15 web pages will come up. It's not hard to find me. I need to be found so people can hire me. He needs to be found so we can sell his products and his merchandise. Now, literally, we don't have to suppose. We know as a simple logic, All he had to do was 20 seconds later, Ray Davis, Las Vegas, Nevada, poker player. Boom, there he is. Picture, address, his business, his location. Oh, I remember this guy. Oh yeah, he's got an apartment over there. Now, that didn't happen here. The fact that the cat team thought he was in California, it is irrelevant. That's not the analysis. It is the government. And the reason the law exists is to force the government bureaucracies to function in a way that respects the citizens' rights. Now, I'm sorry the metro's gotten to be so big. As a personal matter of policy, I think the county should be broke up into 4 or 5 smaller counties. But that's my view. The reality is since everyone wants to have this enormous Clark County, the bureaucracy has to be made to work. And it is not Mr. Davis's fault that this case got so old. He bears zero responsibility here. And literally, the grossest of negligence. Type in his name. There he is. Literally. And you can do it on the website. You'll show up. Now, Your Honor, this case, the Inzuza case is completely controlling this. I mean, as they say in law school, in first year law school, this case is on all fours. And it is.
So the court wanted to know what the difference was because they believed that he was in California.
Right, because Kat had testified, right, that when they get warrants, one of the things that they do is they run the name, the driver's license, things like that. And if they see an out-of-court state, that affects what they go do. If someone's in state, then they use different resources, they know the person's here. If they don't do that, it runs, so I was just wondering.
Right, so Sergeant Beck testified about a solvability factor, and they do prioritize their cases and people that they feel are local, that are easier to apprehend. They do, I guess, prioritize their cases in that fashion. Again, because we're unable to locate any case notes, I can't tell you other than this NCIC modification that obviously means that they were aware of all of his other names that were used, I believe, in Washington State and Wisconsin. Wisconsin or Minnesota, I don't want to misspeak. And those social security numbers that perhaps they didn't believe they had good information on him either based on that. I mean, there's a multitude of combinations between those social security numbers, driver's licenses, social security numbers, birth dates, and names. So I can't, obviously not knowing exactly what he did, someone certainly made sure that good information was in NCIC to try to apprehend Mr. Davis.
Your Honor, and he's on the courthouse's jury service roll. If you go down to jury services, he'll come up on the jury service roll. He's received jury summons for this courthouse. Now, my colleague is doing the best to try to defend an undefensible position, but this is just the grossest of negligence. He's got a power bill, he's got a jury summons, they've been to his apartment. If there's a team of officers whose job it is to go find people, the very first thing you do is read the file and get the address of the guy where every interview I've ever seen. This interview is being occurred at whatever the address is, it's in the file. Literally, I'm in charge of finding the guy. Here's his address, let's go get him. I'm sorry the bureaucracy's gotten this big, but it has, and it's offended his rights.
One thing I did want to correct for the record, Detective Martinez has never been in Mr. Davis's home. He went to his house, put a card there, Mr. Davis returned a call, denied knowing the victim, and said he didn't want to speak. And that was during the course of the investigation, I believe in February of 2016 or January.
Yeah, I like to address this.
17.
This Officer Martinez, badge number 7775, he went to he got an electric bill, warrant for electric bill, which was what I went pro se when I was representing myself in trial. It was in warrant for the electric bill was in my discovery. Was in my discovery. So he knew where I went. What he did was he went to my apartment complex and he talked to my management several different times. They says, yeah, he lives there. He's been here for 10 years. Detective Martinez put a card on my door. I was at my store. I came back and called him, and he explained what was going on. And I said, if you need me, I'm here. I explained to him I'm not going anywhere, any kind of investigation. I never heard from him again. Then I received 2 jury summonses, which the court got. I got stopped by Metro Police 2 times. I bought a red Camaro, custom plates. I registered it with DMV twice. I got stopped in that car twice by police, which time they took my driver's license, they ran it, they let me go. I was walking to 7-Eleven, taking my nephew to the store. They stopped me, put hands on the hood, gave them my ID, they ran it, let me go. This is in 2018. My house was broken in 2017. I called the police. He says, well, nothing we could do here. I gave him my ID, they ran it, nothing we could do here. I ended up suing my complex, which I won one case. So then detective, every day on social media, my whereabouts, anybody knows where I am. Anybody. I did tax returns here. I got tickets from the court, tickets here that I paid. I went down to the clerk and paid. When I got paid public appearances to go to Venetian, go to Westgate, these casinos advertised that. It was an incident at the Venetian at my last Real Grinders tournament that I had there, where got in an altercation with someone. Security came, police came, they ran me, and that was it. At no point in time, since I haven't been in California since maybe 2018. I only go to California if I have a tournament. My over 20 witnesses, they're character witnesses. The witnesses that I have, the main character witness, Kenny Flowers, who stayed with me, was my personal, but not only my friend,
Hold on,
but
I just want to, I want you to, we had a hearing, right? So
Right.
I want to keep it within the evidence that was
Right.
presented at the hearing. So I need you to keep, that's the point of the docket hearing. So I need you to stay within the evidence and the arguments that were at the hearing.
So when they put in the 20 witness list, all of those are character witnesses because DA Stacey Collins introduced bad acts. So when she opens the door for bad acts, she can open up to show good characters. Those people on that list are not privileged to what happened in 2014 or 2016. They know nothing about this case. They're witnesses towards my character.
Got it.
My other witness, the one that was on the alibi list, is senile, practically going through Alzheimer's. I stayed with him. So,
Talking about Fred?
yeah, so when you talk about 6 years and 4 years, well, a few years ago he was sharp, but now he's not as sharp. I mean, he didn't even remember the year when he talked to my last friend, when he had the last conversation. He did not even remember the year that me and him actually met. Not only was it 2 witnesses that passed away, it was 3. His wife, who I was very close to, passed away, and I was there when she, you know. So to say I was hiding, at no point in time have I ever hid. At no point in time has anyone, Metro Police, anyone, California, ever put in an alias. These 10 Social Security numbers or whatever she got was ran by private detectives. None of them came back to me.
Okay, we try to stay within
Okay.
what evidence that was presented.
Right. So basically, I never hid from no one. The police could have called me and I would have came in. I had no reason to hide. Every day that I went to my store, I posted on social media where I was. Detective Martinez knew my he knew my Facebook. He knew where I was at all times. Metro at no time did not know where I was for the last 6 years, since forever. They always knew where I was. If I had a warrant, I would go down to the court, squash it, and deal with it. I don't think I'm hiding by buying a custom Camaro and putting custom plates on it. Never had no run-ins with the police. Every time they stopped me, I stopped. Every time I gave them my ID. At no time did they ever stop me that they did not run. Even when this case, when I was arrested and on house arrest, the police stopped me. I gave them my ID. At no time and point would I hide from the case.
Okay.
briefly, I apologize. So, he indicates he had contact with law enforcement in 2017. He's actually a burglary victim in 2012. So there's no event number for 2017 with Metro, it's from 2012, prior to the investigation. Of all of his police contacts in the last 10 years, that is the only time he has used the Nellis address. He has always given 6308 Southeastern, number 10, Bellflower, California, 90210, or Telegraph Road, and I believe that's Bellflower as well. And his last two pawn events, he gave 2750 South Durango here in Vegas and 5600 Boulder Highway. So he has, with his law enforcement contact, he has not consistently used that Nellis address. And there was, as far as I can tell, there's no 2017 burglary report unless it's with another agency.
So how many incidents?
So, 2013, February 3rd of 13, he gave the Telegraph Road, California address. The 2004 case that's subject to the bad acts here, he gave the Bellflower address, 6308 Southeastern, number 10, Bellflower, California. When he reported his burglary, he gave the Nellis address, and when he pawned in 2011, 2012, he gave the alternate Vegas addresses.
It's strictly speaking, Judge, hearsay, my colleague is supplementing the record. Now, we're going to revisit the testimony, we'll have another hearing.
I can call a witness, I'm an officer of the court.
Okay, here's the thing. I agree that there are many similarities to Nzunza, however, I do think that there are differences as well. I think that my reading of Nzunza was detectives were given the make and model of the car, his Facebook page, where his girlfriend or his wife, I can't remember who it was, said he was living in New Jersey in this area, his work. And they had reached out to the detective on multiple occasions updating this information. Here we have the detective who turns it over to Kat, and then we are looking at a Kat detective who runs the defendant, or who presumably runs the defendant because we have out-of-state addresses, and Detective Sergeant Beck discussed what happens versus in-state and out-of-state. But I think the biggest issue that we have here, which we didn't see in Nzunza, and the Supreme Court talked a lot about in Nzunza, was that in Nzunza, the state failed to make any rebuttal at all. And here, that is not the case. The state has made several rebuttal arguments in regards to the information relating to the two deaths of the witnesses, the video of Fatburger, the reality of whether or not there would be forensic evidence, and this whole thing about delayed disclosure, and whether or not the victim remembering certain dates, and then furthermore, the fact of, you know, the defendant wants to call these two individuals to talk about his comings and goings, but the defendant also, on the other hand, states, well, I'm this public figure, and it's always on my Facebook when I'm traveling, and I can get all the evidence for which hotels I was at during which places and which poker tournaments I was in. And so for those reasons, I think it's a close call, and I said that from the beginning, but I do think that this is different in Nzunza for those reasons, so I am dismissing, or I am denying the motion. I had a written order previous to Nzunza, which was consistent with my previous ruling. However, I now need to add the stuff from Nzunza, which I will try to do today and get a copy to each of you by 5 o'clock, as long as I have enough time to do so. So that being said, we will resume in this case with trial on Monday at 1 o'clock.
Yeah, I'd like to put in a motion to dismiss counsel, please.
Okay, let me just deal with one thing at a time. Mr. Mueller.
Thank you,
Well,
Your Honor.
actually,
I believe,
sorry, Mr. Mueller, I apologize, I don't mean to cut you off, but I do think I need to handle a motion to dismiss counsel before I hear representations from counsel. Yes?
Yes, I filed a motion. I'm going to file this motion to dismiss counsel.
Okay, we'll file that, please. And what is the basis, sir?
The basis is, you want to read it?
No, I want you to tell me it, because I can't.
Well, the
research
basis is, the basis, Your Honor, is I've been in custody maybe 5 months. I hired Attorney Miller 4 months ago. I rehired him. I have had one visit. I paid cash. He got paid in full. I have had one visit for 20 minutes since I've been in over 4 months. I'm not able to talk to him. I've talked to him for 4 minutes on the phone. I have no contact with Attorney Mueller. He refused to visit me, he refused to see me. January the 17th, I was in your court for another hearing to dismiss counsel. You asked Attorney Mueller to come see me. He has yet to see me. He has yet to make any effort.
Just 1 second, in fairness to you, Mr. Davis, Mr. Mueller
He was in trial.
he was in trial in my department, and so I don't want you to think, I mean, he was actively working day
Yes.
and night in regards to that trial. And I also have to say, his briefing in regards to this, and his supplement and addendum were excellent. So it's not like he's not, I mean, he is working hard for you.
Your Honor, I question that because I went over the briefing too, and last night I went over Azuzu for 2 hours on the kiosk. And a lot of the points was missed in here, and a lot of the points were, the dates were wrong and stuff like that. So, and then you seem to talk about my popularity and stuff like that. Well, in
You
2000,
talk about your popularity.
you seem to say I can get witnesses,
No, I didn't say
that I can get witnesses to defend myself. Back in
I did not say that.
well, you're saying I can bring.
No, what I said is, one thing that you have said to me in court is that because you're such a public person, you have a page that details all of your poker winnings and all of the tournaments that you have been to, and also the hotels sponsor you and things like that, and so it's easy to Google where you were when. I didn't say anything about your ability to get witnesses.
Okay, Your Honor, how do I supposed to defend myself when I had a lawyer for 20 minutes? 20 minutes, a lawyer that visited me for 20 minutes who knows nothing about my case. I know Mrs. Collins is scared to go against me again because the last time I tore her a new one, and I will tear her a new one this time. I have a right to defend myself, a constitutional
You're
right
going to be
afforded.
respectful, and you're not representing yourself. You and I have already talked about this. You lose the right to represent yourself when you cannot follow court rules and court guidelines. I looked through our trial transcript, sir, you did not follow a court rule any day of the 5, 6, 7 days we were in trial. You're not representing yourself. It is time to go to trial. Mr. Mueller will continue to represent you. Nothing that you have brought to my attention makes me feel like he is ineffective in any way.
So attorney visiting you one time for 20 minutes in 4 months
Mr. Mueller, trial will be
proper?
starting on Monday at 1 o'clock. If you could be present with your
This ain't proper?
clients.
Has this
And
been
also
filed?
if some communication can be made with him before the trial is to begin, so that he can feel like preparations are in order.
Your Honor, this hasn't been filed. Can you file this?
What is that, sir?
It's motion to dismiss counsel.
What did I just file?
Okay, so this is my copy? Okay, also I got a couple of other motions that's
Okay, but you
pending.
can't file motions because you don't represent yourself.
Well, I
So
can
those are
file a
fugitive-
motion to dismiss counsel.
And
That
you
is
are,
one motion I
and
can
so
file.
I'm having that filed, and that has been filed.
Also, I got a court date, the 10th to dismiss him, and a court date, the 19th to dismiss him. Also, this is pending in the Supreme Court.
It is not
Don't-
pending in the Supreme Court.
It's
You
not-
have counsel. You
Not
cannot
for the
file.
motion to dismiss.
Oh, okay.
So I got the case number right here.
No, that's fine, I believe you. If the Supreme Court wants to deal with that and say your case, they can do that. Mr. Mueller, I'll see you on Monday at 1 o'clock, sir.
Thank you, Your Honor. I'm going to ask for with this motion to get a supplemental investigation. I have something I need to run the ground.
I'm sorry,
I'm going to be submitting a witness motion this afternoon. I've got something I need to run the ground. I honestly like to dismiss today, so we're ready to go.
okay, a witness motion for like investigative efforts.
Yes.
That's fine, just get it into me and I'll sign it today.
The state is still waiting for the phone numbers for the 20 witnesses.
Okay.
And I gave Mr. Mueller the new return from Facebook today on a disk.
All right, and for the record, Judge, respectfully, I'm required to say this, I believe the court's ruling is an error. Respectfully, it is a manufactured analysis in favor of the state, and I don't believe this is supported by the record.
Attorney Mueller, will you file it with the Supreme Court, please?
Yes, I will. Okay. All right, you want to do that? Fine. You're not going to ask the court to stay the proceedings so I can take an interlocutory appeal of the Nevada Supreme Court.
Okay, so the motion for stay is denied overnight. If you want to do an emergency stay and they deem fit that they need to intervene, they will do so.
Thank you.
Thank you.
You said 1 o'clock, I'm sorry.
1 o'clock Monday.
Thank you.
946-1, State of Nevada versus Raymond Tyrone Davis. Mr. Davis is present in custody. Hi, Matt.
Hi, Kevin Ramsey. I have a Craig Mueller's office. Mr. Mueller's in Henderson right now. This my understanding is Ms. Collins is in a grand jury, so we're asking to pass this until Monday.
That's correct, Your Honor.
Okay.
Thank you.
February 24th, 9:30.
Thank you. Thank you.
She doesn't hear a motion.
No.
She doesn't have to let you proceed with formal She did?
No, not the one in 19.
I think that was
All right, page 44, C-3429 for 6-1, State of Nevada versus Raymond Tyrone Davis. Was present in custody, Mr. Mueller on his behalf, Ms. Collins on behalf of the state.
Good morning, Your Honor. Good afternoon on behalf of Mr. Davis.
Okay, so this is defendant's motion, notice of motion for reinstatement of own recognizance. I've read everything on both sides. I'm happy to hear additional argument if.
Very briefly, Judge, I do a fair bit of appellate advocacy. This case is now stayed. The court, Supreme Court has heard the state's view, our pleading papers, they've seen the court's order, and they've continued the injunction, which means Mr. Davis is now being held indefinitely. It could be 3 or 4 days, it could be 5 or 6 weeks, it could be a few 6 months. And Mr. Davis made all his court appearances prior to the first trial when he represented himself, not miss anything. He is very unlikely to not come back again this time. Additionally, Mr. Davis is in poor health. He has blood in his urine, and the doctors are wanting to perform surgery on him. So respectfully, I'd ask for an own recognizance if as soon as you still have an apartment?
Yes, sir.
He's got his apartment. So we could, if you're concerned about public safety, we could have him on house arrest, either his business or his apartment. But the reality is this is now an indefinite detention with no end in sight. And Mr. Davis has made all his court appearances. And I don't think lawyers make very big fools themselves when they try to predict an appellate court. But I think the writing's on the wall here with their reaffirming their injunction after they've seen all the pleading papers.
Tell me more though about this surgery, like is something scheduled,
It's not scheduled. Other day, since 3 months ago, they started doing tests on me. They never got, I was in severe pain, peeing every half an hour, that's why I kept on going back and forth here. They never, this happened and they never treated me. They never got a diagnosis. They never got anything. They never came back to me, something's wrong. Only thing they told me was, well, you have high blood pressure, which I never had before in my life. They said, you know, it's probably because of the jail conditions or whatever, stress. So they put me on blood pressure pills. I asked them, maybe I put in about 15 kites. I got them all right here, saying there's something seriously wrong with me. I'm in severe pain. When I use the bathroom, my kidney air, they did nothing. They took 4 urine samples. Finally, they moved me to NVC. The doctor comes in. He don't say anything. Last Friday, this Asian doctor, Wednesday, Asian doctor comes in. She says, I got good news and bad news for you. Which one you want first? And I said, whichever. She says, well, good news is there's no blockage. The bad news is you got blood in your kidney. That's why your urine. You need to go to the hospital immediately. And I asked her, she said, this is bad. And then she kept asking me, when are you going to be released? I said, I don't know. They take me back to my unit. They asked me, when am I going to be released? I said, no, I don't know. 30 minutes later, they rushed me back down here because they said, we can't keep you here because of your health. They rushed me back down to the county. They didn't schedule a surgery. She scheduled me for hospital visits, but they won't take me.
When's your first hospital visit?
She scheduled me for a hospital visit. She said they supposed to take me immediately to the hospital, but nobody's taking me. Every night, I'm in pain. I told them months ago, she said the doctor, she said they should have detected this 3 months ago. That's her exact word. She says you can, the courts can get her records or whatever. That's her exact word. They should have, she said whoever doctor was on this didn't diagnose this 3 months ago. Obviously, your condition has gotten worse. She said they were taking me to the hospital for all kinds of tests and stuff immediately. Still, that was last Wednesday, it's Monday. I'm still sitting there. I'm still in pain. Your Honor, in 2004, 2005, I picked up cases in Vegas. I didn't live in Vegas. I lived in California. I made 7 court dates in 2004. And then I made, 2005, I made every court date. I've never been a flight risk. I never missed a court. I don't know where they get 15 court dates. I have never missed a court date in my life. I would have to be dead.
Right.
Officer
Wait,
O'Connor.
so 1 second, hold on 1 second. So I was just asking you about your health conditions.
Right.
So, Ms. Collins, if you don't need to address the health issues, I was just asking in regards to if we have upcoming surgery dates, but anything you want to address in regards to Mr. Mueller's representations or in regards to the motion in opposition?
So when I read the first stay that was waiting for documentation and for them to supplement, that stayed the trial. The second order stayed the proceedings in total. So that was, I looked at that after I filed my opposition. I don't know if this court has jurisdiction to hear this right now because the entire proceedings are stayed in the Supreme Court. I guess you could presume to honeycut, but that being said, I don't think anything has changed. There's certainly an assumption of the risk by them filing a petition asking for a stay. Nothing has changed regarding Mr. Davis's actions, his activities, his history, his criminal history. If there is something health-wise that needs to come before this court, the state's going to ask for documentation. I mean, Mr. Davis came to this court several times during the course of that trial and expressed, that he was medically compromised and had a surgery scheduled mid-trial and all sorts of things. If these things are documented and there's a serious health issue that the court wants to consider, then by all means consider it. But right now, I'm sorry, I can't take Mr. Davis at his word based on his history. That's where I'm at.
Well, I don't get involved with the jail and the health stuff. If the doctors at CCDC deem it appropriate for him to go to the hospital, I don't get in the way with that. I just wanted to know if there was a pending, hospital surgery set, so I knew, so I could put it in my notes. But in regards to, that's really between Mr. Davis, Mr. Mueller, and what's going on at the jail in regards to the health issues.
There being no court date pending, Mr. Davis repeatedly invoking his speedy trial right. The state, the government, the Supreme Court has stayed further proceedings. I mean, what's coming is not going to be hard to predict. They're going to eventually overturn and dismiss this case. Now, Mr. Davis, in the meantime, is in a deteriorating health. He's no reason he can't be released. He's got a place to go to. He's got a business to run. He's got one of his loyal employees here in the courtroom. She desperately needs his help with the business. And I'm going to ask the court to give him an home recognizance with either the house arrest or if the court's concerned, house arrest so he can at least go to his business location in the park.
Question about the business, and this is something that we should probably address because multiple times Mr. Davis has discussed on the record his, for lack of a better term, monetary status. He's told us multiple times how much money he has and that he's won several $1 million, and he's talked to the jury about that. And then last week I received a witness motion, which I granted because it was told to me. I read it and it said you need it, but I do need to make sure I'm doing a full canvass in regards to that because of the representations that were on the record multiple times. And you know what I'm talking about, Mr. Davis. You had made multiple representations in regards to the millions of dollars.
Your Honor, I won $7 million,
Okay.
and I lost probably everything gambling. I went to Gamblers Anonymous. I had a serious gambling problem where I would lose $20,000, $30,000 a day. That's common for a gambler to go through his accesses to money. I brought numerous cars, jewelry, everything. I blew probably every dime I ever had, every made.
Okay.
My circulation of money is based on my business partner is ready to close the store, can't make no money without me. My employees, the people that help me, they can't make money. I'm responsible for thousands and thousands of people coming to this town for tourists. They are no longer coming here. We have tournaments sponsored at Venetian, all over the place, Westgate, all these places. This is no longer able to happen. I am put in a financial strain where I have no more money.
Okay, that's all, I just needed to establish that, because I just, as a judge, and make sure I'm approving the right funds, I just have to make sure that because of those representations you had made originally, I don't have a problem signing the witness motion now that the record is clear that at this point in time, the previous financial representations that you have made have changed, and that is why the witness motion was filed. In regards to the motion, there has been nothing that has changed in regards to my previous ruling. If the Supreme, and I do think that the Supreme Court does expedite these things when we're in custody. I've had certain situations in the middle of a trial it happened and get a turnaround in like 48, 72 hours. So I do think that they're probably honestly working diligently right now. If I am wrong and they overturn me, like Mr. Mueller thinks that they will, as soon as I get that notice, I will obviously dismiss the case and release you. But as far as the changes being in the any change in circumstance, I don't believe that there has been any change in circumstances for me to make any change in the current motion. If the defendant is not seeking the medical care that you believe he needs and that he's entitled to, I'm happy to hear about that and make sure that he's being transported for hospital visits or if he needs a surgery or something like that.
If I could stop at this point, Judge, I used to be in the Navy, as you know, and if I called somebody and said, this is Commander Mueller, things got done. When I call up and say, this is Mr. Mueller, or this is Craig Mueller, things don't happen. Now, if I call that jail and say, this is Craig Mueller, I need you to look at my client's health, nothing's gonna happen. If you call over and say you're Judge Bluth, he'll get seen. So if you, at this point, I'm gonna accept the court's offer, and please have somebody call from your chambers and get him checked out. I've got access to a physician. When I asked her about bleeding kidneys, she said that's very serious.
Okay.
The doctor said you could call them from your,
What is the doctor's name?
she wouldn't, well, I was seeing Wednesday, she says, when I left, I mean, obviously I didn't have nothing to write with or whatever, she says the courts can call her immediately.
So, but you don't know her name?
No, they got it, the sheriff's got it.
So you saw
She's
her
an
on Wednesday?
Asian lady, and she was at NBC. I saw her Wednesday, and she said she has no problem talking to the courts.
Where did you see her at?
North Vegas.
Oh, North Valley?
North Vegas, that's where they had me. North Vegas facility. Your Honor, and also, I made 30 court dates.
No, I know, we're not addressing that. I'm dealing with your health right now. All right, so I will have my chambers reach out to and make sure that everything's being done in regards to health. And I'll see if we can make contact with the Asian female doctor who saw him on Wednesday last week. All right, other than that, the